It is important for Canadians to understand the unprecedented, critical situation that the country was facing earlier this year. The evidence will show that the invocation of the Emergencies Act was a reasonable and necessary decision, given the escalating, volatile, and urgent circumstances across the country. The evidence of the government witnesses will detail the facts and events leading to the decision to declare a public order emergency. They will describe the countrywide threats to the security of Canada, the illegal blockades, the disruption and intimidation experienced by Ottawa residents, the threats at our borders and ports of entry, and the real impacts on Canada's trade, international reputation, and the economic well-being of Canadians. The government witnesses will outline the deliberate, step-by-step process in which careful consideration was given to all the available options which led to the declaration of a public order emergency as a matter of last resort.
It is our view that there was no justification whatsoever to invoke the Emergencies Act. The Emergencies Act requires several things. One, it could be invoked due to espionage and sabotage. Are you going to hear any evidence about espionage and sabotage? The answer to that is no. Two, it could be invoked on the basis of clandestine or deceptive foreign influence, or foreign influence that involves the threat to a person. Are you going to hear evidence about that? The answer to that is no. It also could be invoked on the basis of threats or use of acts of serious violence against persons or property. Are you going to hear evidence of violence against persons or property? The answer is no. Lastly, it can also be invoked if there is a group or persons trying to destroy or overthrow by violence the system of government of Canada. Are you going to hear evidence about individuals trying to do that? The answer is no.
Saskatchewan's position is that the federal government had already determined that a nationwide emergency would be declared before the First Minister's call on February 14th. The call was not so much about consulting as it was about telling. The third area concerns whether the emergency measures were overbroad. The financial measures, for example, imposed broad responsibilities on financial institutions with little guidance, and they created offenses for not complying with those new responsibilities. The final area concerns to what extent Saskatchewan residents were impacted by the emergency measures. The government is concerned that residents' rights may have been unnecessarily infringed by these measures.
Alberta believes it is important to share with Canadians the facts about how Alberta was able to effectively deal with the international border blockade in Coutts, Alberta, prior to the invocation of the Federal Emergencies Act. Alberta's evidence will show that the existing law enforcement tools that were already in place were completely sufficient, and they were successfully used to peacefully restore the flow of traffic at the Coutts border crossing and to disperse the protest to a legal protest site. None of the powers that were created under the Federal Emergencies Act were necessary, nor were any of them used in Alberta to resolve the Coutts blockade.
The first convoy participants arrived in Ottawa, not far at all actually from where we sit today, on January 28th, and they remained in our city for approximately 3 weeks. I expect you will hear from witnesses about the significant impacts on the city's residents and businesses, and you will also hear about the city's efforts to support the police-led response to the convoy and to mitigate impacts on city services.
The impact on Ottawa for those 3 weeks of harassment, street blockages, ear-splitting air and train horns, and general lawlessness was unprecedented. Many people in Ottawa felt like they were prisoners in their own home, and they felt abandoned and they felt unsafe by the police and by all levels of government. The Ottawa Coalition is not going to take a position we don't anticipate on the Emergencies Act, but make no mistake, it was a crisis in downtown Ottawa. There was disorder, there was chaos, there were propane tanks, there were gasoline jerry cans everywhere, there were fireworks going off at all hours of the night, pinging off buildings, pinging off windows. People could not get, there was no public services, paramedics, ambulances, no buses, no taxis, grocery stores were closed. Businesses, several hundreds of businesses are closed. The Rideau Centre, the major mall in Ottawa, was closed for the first time in its history for a prolonged period of time. The people in Ottawa are still traumatized, Commissioner.
There is a well-established process you will hear that the Ottawa Police Service follows when protests occur. The police must respect the charter right to peaceful process while at the same time protect the community and uphold public order. The Ottawa Police, you will hear, follow that well-established process that had always worked with protesters, this time as well, and were prepared for an event, but not for the event that occurred. Why? What you will hear is that this protest was unique in Canadian history. The police had little time to prepare. The genesis of the protest had only begun a couple of weeks before it arrived in town, and it gained momentum with time. What none of the intelligence predicted in the very brief period of time prior to the convoy's arrival was the level of community violence and social trauma that was inflicted upon the city and its residents.
The City of Ottawa was ground zero for the protests that occurred in February 2022, and Chief Slowly will assist you in understanding the challenges faced by the Ottawa Police Service in addressing the evolving illegal occupation. As he will explain, the events represent a paradigm shift in public protests. In particular, he will explain to you the limited resources available to the Ottawa Police Service to deal with a massive occupation, the limited nature of the intelligence available to OPS about what was coming Ottawa's way, the importance of the right of lawful protest in our democracy, and the limits of the authority of the Ottawa Police Service to deal with protesters.
For 34 years, the Emergencies Act was never used. The public order emergency of 2022 was a historic first. But now that the glass has been broken on the Act, it can be used again. The Act was used by this government against individuals protesting vaccine mandates, but a future government of a different political stripe could use the Act in response to protests against pipelines or climate change. When the Commission asks hard questions about the Act's use in 2022, the Commission must also focus on the Act's potential misuse in the future and protect the right to protest, parliamentary democracy, and federalism. And what the Commission says matters not just to Canada, but globally, where the use of emergency powers is on the rise. The world will be watching our work.
There are many issues that the Commission will be examining which are central to CCLA's work, including the lawful scope of the right to protest, the role of police in facilitating protests while protecting public safety, the relationship between policing authorities, civilian oversight bodies, and government actors, and the surveillance of those involved in dissenting social movements. More broadly, the CCLA's interest in the Commission's work goes to the core of the organization's mandate, protecting the rights and freedoms of Canadians and demanding transparency and accountability from our governments. The CCLA views the Commission as an instrumental part of achieving the goals of transparency and accountability, and our participation in the Commission's proceedings will be aimed at supporting those goals.